Oh, see, there it is. Testing, testing. Test. There's just an echo. There's even an echo picking up. Test. Can you guys hear me on Zoom? Yes or no? Is there an echo?
We can barely hear you, Megan. There's a little echo, but wasn't as bad as it just was.
Okay. Can you hear me now?
Yes, that's a little better.
Okay. Thanks.
Yep.
We're having a little audio issues here. And I don't know how to get rid of the echo fully. Test, test. You still hear me?
Good afternoon. You sound good, Megan.
Okay, great. Thank you. Good afternoon. All right, good afternoon, everybody. We're going to get started in just a minute or two. People are still joining and settling in here.
And I did want to just let you know that I will have to excuse myself at 1 o'clock for a mandatory commissioners meeting.
Okay, thank you very much. Thanks for
You're
letting.
You're welcome.
Good afternoon, everybody. We're going to get started in just a minute or two. Folks are just settling in here. We'll get started in a minute or two. All right, good afternoon, everybody. I am going to call the meeting to order. It is 12:32 p.m. And just first order of business is just welcome and introduction of council members. So I'll start with the folks in the room and then move to the folks on Zoom. So obviously, good afternoon. My name is Megan Scanlon. I'm the co-chair of the council from CCADV.
My name is May Flexer. I'm a state senator from the 29th district, and I am the other co-chair of the council. And this way? Yeah.
Good afternoon, Valina Carpenter from the Office of Policy and Management from the Criminal Justice Policy and Planning Division, new to the council, but certainly not new to, this issue or this space. So very pleased to be working with so many familiar faces again.
Hi, I'm Joe DeTuno. I'm the Director of Family Services, part of Connecticut's Judicial Branch.
Hi, Danielle Cinquedolce. I'm the Regional Manager for Family Services, part of Connecticut Judicial Branch.
Good afternoon, Phyllis DeCara, member of the board.
Good afternoon, Nancy Turner, representing the Board of Pardons and Parolles.
Good afternoon, all. Alaric Fox, Chief of Police, Enfield Police Department.
Great, thank you, everybody, and welcome, Valina. We're very excited to have you. Okay, I'm just going to go by my boxes. So, Gail.
Good afternoon, everyone. Gail Hardy, and I'm the Chief State's Attorney's designee.
Great. Judge Doyle.
Good afternoon, Kevin Doyle. I'm a Superior Court Judge.
Thank you, Andrea.
Good afternoon, Andrea O'Connor. I'm the Family Violence Victim Advocate Program Manager for the Umbrella Center for Domestic Violence Services.
Thanks. Merritt.
Good afternoon, Merritt LaJoy, Office of the Victim Advocate and co-chair of the Court Issues Subcommittee.
Ginger.
Hi, I'm Ginger Wilk. I'm the Senior Director of Reentry Services for Community Resources for Justice, Family Reentry.
Great. Nancy.
Good afternoon, everybody. Nancy Tyler, designated by CCADV as the survivor representative.
Thank you. Welcome. Johanna.
Good afternoon, everyone. Johanna Canning, designee of the Chief Public Defender. And I just want to apologize in advance. I'm not feeling well today, so I might have to step out early. No disrespect meant there.
No worries. I'm just getting my voice back, so I get it. Sarah.
Megan, it's my understanding that Sarah's having trouble with her speaker,
Okay.
but she's attending.
Okay, we can see you, so we know you're here. Thank you. Captain Party.
Good afternoon, everyone. Heather Party. I'm a captain with the Windsor Police Department in charge of the patrol division.
Great, thank you. Miss Garcia.
Good afternoon, everyone. District Administrator, Director of Programs with the Department of Correction and designee for Commissioner Angel Heroes.
Awesome. And I don't think I've missed anybody, so I'll just move to CCADV staff. Shauna.
Hello, everyone. Shauna Harrington, Director of Legal Advocacy.
Gary.
Hi, everyone. Gary Wallace, one of the VPs of programs at CCADV. I'm in transit, so I'm off camera.
Okay, thank you. And then in here, we've got Mario Volpe, our policy manager, and Liza Andrews, our VP of Government and External Relations. Okay, awesome. Thank you. Anybody that I missed, either that came late in Zoom or I think I got everybody. Oh, Captain Maynard, actually. It's just, you got right in there. Good timing.
Hi, sorry. Yep. Thank you, Captain Ryan Maynard, Connecticut State Police.
Okay, good. Nice. Always on time, reliable. Okay, moving on to the approval of the December 17th meeting minutes, item 3. I just need a motion to approve the minutes.
So moved.
Any, thank you. Any edits, discussion? Or second, sorry. I think there was a, is there a second?
I'll second.
Thank you. Any discussion or edits? Okay. All right. All right, well, no discussion or edits. Move that the meeting minutes be approved. All in favor?
Aye.
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 Any opposed or abstentions? Okay, great. Awesome. Thank you. All right. Next item are the subcommittee reports. I will move to item A, police response to crimes of family violence.
So once again, good morning all. Alaric Fox from the Enfield Police Department. A relatively light report, but a positive report with great work done by Joe DeTuna and Karen O'Connor, Karen Foley O'Connor, my co-chair. We have at least some draft language that we've put together that's going to work its way to our subgroup, our subcommittee, as to the alert notification GPS program and some areas where we all thought that we could improve within the policy. We have that draft put together. However, our subcommittee has not met as a group. It was a little bit of a lift to even get the language put together. We are, however, making progress in that direction. Thank you.
Thank you. Any questions for Chief Fox? And I think Sarah's trying to get readmitted, Kirsten. Okay, all right. Good. Okay, any questions? I don't see any on Zoom. Any here? Great. Moving on to B, court-based issues.
Can you hear us? Can you hear me?
Yes, good. Yes, can hear you.
Great. Yes, we had a meeting last week and we are continuing to work on the eligibility and requirements for domestic violence component of STP, Supervised Diversionary Program.
Okay, great. Any questions for court-based issues? Okay. I guess I have one. Do you have a timeline as to when you think you might have something to bring before the full council? Just thinking about our next meeting date will likely be in April, so I'm just trying to think.
Probably probably not before then. We're
Okay.
working on some statistics and trying to come to a consensus.
Okay, great. Thank you. Okay, any other questions, comments for court-based issues? Okay, I'm not seeing any on Zoom and I'm not seeing any here. So moving on to firearms seizure and compliance working group update.
Hello, everyone. So I have a little bit of a longer update than my colleagues here, just because we are a new group. So just to give everyone a little background on what we've been up to. We held our initial meeting on February 6th and a second meeting on February 18th. Going forward, we do plan to meet once a month. At our first meeting, we identified a few priority areas, including reviewing the firearm ammunition and compliance statement, which is the DPS-332C form. We reviewed the language in the model policy that discusses the use of this form and if it would be beneficial to make the language more mandatory rather than saying that officers should consider having the offender complete firearm ammunition and compliance statement. The group also discussed there's really no incentive for folks to fill this form out, and it could also present Fifth Amendment self-incrimination issues. Additionally, the group talked a lot about the concerns around illegal versus legal firearms and how ideally we would like to come up with a procedure that targets all firearms, understanding that no one approach will be a one-size-fits-all. For next steps, the group decided we could benefit from seeing the current written compliance procedure provided by the Special Licensing and Firearms Unit and comparing it with our goal procedure. We also discussed looking at Connecticut General Statute Section 46B-38B, subsection A, to see if there's any work to be done in amending the language that currently says an officer may seize firearms at the scene. Lastly, we discussed the risk protection order route as a potential option for victims who know an offender did not comply with relinquishing firearms. Our next meeting will be held on Wednesday, March 18th from 1 to 2 p.m.
Thank you, Shauna. That was really great. Any questions for firearms working group? Okay, and then I do just want to acknowledge that Mark Pelka, who's the director of the Office of Victim Service. No, not trying to call you out, just trying to recognize that you're here and give you credit for being here. Sorry.
I'm so sorry.
Just joined us in person, so welcome. Okay. I am not seeing any questions or comments. I guess one question for you, Shauna, is the plan for the group to bring something to present to the full council by the spring, or do you need more time? Again, I'm just thinking about next meeting and planning.
We discussed getting a recommendation to either one of the subcommittees by the summer.
Okay. All right, great. Thank you. Okay. All right. Any other questions? All right. We'll move on to the next item, which is just discussion regarding clean slate and Connecticut General Statute 46B-38H. I am going to try to share a quick little PowerPoint with I guess I don't have the ability to share. Okay. Okay. Host only. Okay, can you all see these slides? Yeah. No, it's okay. Can you all see these? Yes. Oops. Yeah, sorry. Sorry for the technical difficulties. I'll try to get this up. Um, Okay, sorry about the technical difficulties there, but you should be able to see a slide. Um, hopefully you can see the entire slide for those on Zoom. If you can nod that you can see the whole slide this time, that would be awesome. Okay, so this item came up. I'm just going to give a little bit of context. So as some of you probably know, on the council, we work pretty closely to try to improve responses within systems, especially with court support service and Joe's team. We've always had a really good working relationship, and there was a case that was brought to our attention several months ago at this point that involved a charge that involved, I think, a child in strangulation, because it was the first charge on this individual's record. And I'm obviously like not going to go into the detail of the case. I'm just trying to give a pretty general overview to respect people's confidentiality. But because it was the first charge, the individual was released on a promise to appear. There had been other instances where they had been arrested and charged with, I think it was assault third in the past, but because of the way in which the clean slate statute is currently, that was not on the individual's record. So when it came to determine like what made sense in terms of, you know, bond and release and all of that, that was the determination. So this was brought to our attention. And so I give that as like general context for the conversation because there's a couple different slides. And I know Judge Doyle's going to have some input here too. So we had asked, just as background, for somebody from the Department of Emergency Services and Public Protection to come and walk us through what they use based on the statute. And so they were not able to come. So basically this slide is what is we just copy and pasted from Department of DESP, and this is what they use in terms of the statute. There's really no like subjectivity to this as far as we understand. It's just like if this happens, then this happens, was what we were told by DESP. So there's no like subjectiveness to this at all in terms of what is coming out of Department of Emergency Services and Public Protection. I don't know if Judge Doyle, now is a good time if you want to just describe like what happens from the court side on the domestic violence flag, or if that is exactly the same.
Let me see. Thank you, Megan, first of all. And I hope to provide kind of an overview based on my understanding and kind of how things work, and then we'll see where it goes. So I appreciate your patience. The way the system works is if a person pleads to one of the offenses listed in, I want to start with 46B-38H. General Statutes 46B-38H includes about 30 crimes or charges that are considered, if it's against a family or household member, are considered family violence crimes. And it ranges the whole gamut from a C misdemeanor like harassment in the second degree all the way up to B felonies like assault in the first degree, sexual assault in the first degree. So that became the initial starting point for family violence crimes. And then they wanted to create a system that would have certain conditions to make sure they didn't miss anything and that it would be efficient in light of the 2023 amendment. So what they created is a series of, and you see this in the second part of the slide, is in addition to the charge. So it starts with the charge, but then it has certain other kind of catch-all provisions to help so they don't miss something. So if this charge involves at some point a family violence case, which is number one, that generally involves when a person is arrested. And if I get this wrong, I know we have some good officers here who are going to correct me. But generally, anytime a person is arrested, the police fill out what's called a uniform arrest report, or UAR. You know, we in court always talk with acronyms. So the UAR has a specific box on it for family violence crime. All the officers are trained to check that when they make a family violence arrest. That paperwork then gets submitted to our clerk's office at the various GAs throughout the state. So the first thing the clerks are looking for is that box to be checked, because once it is, they code the case as a family violence crime case, and it gets coded that way. I mean, technically, if the officers made a mistake and missed it, many of our good clerks can pick it up based on the nature of the case. The second condition covers cases where at any point during the proceedings, from the point that the person is arrested until the point that the person pleads guilty and gets sentenced, a protective order is issued. That would be a second condition that, if present with a conviction on a charge listed under 46B-38H, will trigger this as a family violence crime. The third box deals with basically at any point when the case comes to court and it's either referred to family relations or family relations does an assessment. Even if they don't take the case, they do an assessment. That will get notified in the clerk's file, and that becomes an additional trigger. So that if a person pleads to any offense listed in 46B-38H, one of those 30 or so offenses, and then at any point one of those three conditions listed on that first slide have been checked, once that person gets sentenced and the clerk's office fills in the paperwork, that information is then sent to CIS, Criminal Information Systems. They log it in, and then it's available to the Department of Emergency Services and Public Protection. And basically, as the computers check, that's going to trigger the presence of a conviction under 46B-38H and one of those conditions to flag it as a family violence crime. And any of the charges that are sentenced or disposed under those are going to be precluded from being erased under 54-142A. So let me ask you first, does that make sense to people? And are there any questions related to that? I think I got it right, but if I missed something, feel free to correct me.
Senator Flexer. Thank you, Madam Chair. Thank you, Judge Doyle. I just have one question just for clarity, especially for anyone who might be watching our meeting. That UAR form, can you just explain what that is? That's the form that
Sure.
President.
That was not my area of expertise, Senator.
Yeah.
So basically, when people get arrested, the police, and I'm sure the officers that are here will correct me if I get this wrong, but part of the paperwork is a form. It has identifying information, the person's name, date of birth, height, and weight. It will list the charges for which the person has been arrested. And it will include this box where the officer will check. It will mean it's a family violence crime. The officers fill out that form at the time of arrest and put it as part of the packet. That packet will then be brought by the liaison officer at the police department or at the barracks to the clerk's office. And that will be part of the paperwork that the clerk's office will get on the first day and have it prepared as part of the file at arraignment. Arraignment will be the first time that a person appears in front of a judge. As we know in Connecticut, for any family violence crime, they have to appear within a judge within 48 hours. So that file is going to be prepared, made up, and the UAR is going to be part of the clerk's file and part of the official record. Does that answer your question, Senator, or do you need more detail?
It does. Thank you very much. I appreciate that.
Thank you.
Any other questions?
I have a question. I don't know who can answer it, but on the slide, you have two codes there, 452 and 453. Can somebody elaborate on those?
Those are the family relations code.
I'm going to turn that over to Mr. DeTuno because I think that's his area of expertise, but I'm pretty sure they relate to, you see 451 is the assessment, 452 would be if it gets assigned to family mediation, but I'm going to let Joe address that further.
Yeah, those are all the codes that the clerk uses when the case is referred to family, and some of them, like honor court and others, are just catch-all, so you don't miss anything. We don't use them anymore, but just in case they're clicked off. But all the rest, FEP application, FEP program, family relations assessment, those are all really what we use now. And supervision, the others are just kind of what they assume are all under family services. So,
thank you.
Any other questions? I'm trying to go through the Zoom too, so I apologize. If I haven't gotten you on Zoom, just shout out your question. Okay. All right. Thank you, Judge Doyle. That was super helpful because then, so the next slide, which hopefully you all will be able to see. Can you all see that slide? Yes. So these are the crimes that are included under the statute right now. So an individual right now, if they were to be charged with this crime and then any of family violence or anything like that that judge just went over, then it would not necessarily, it would not be erased from their record. So this slide and the next slide are the list that are included. And I know I'm going fast. This is also in your packet. So if you, if I am going fast or if you need me to go back to a slide, let me know. Happy to do that. And then the last slide is what I think we really wanted to talk about. These are not included at the moment. And so I think when we were having this discussion, our agency and court support service, there's obviously an acknowledgement that some of the family violence crimes are getting missed. And so this slide is really what we wanted to talk about today and get people's feedback from all your different perspectives and systems as to whether or not we should consider advocating for these to be included or not. Meaning that they would show up on somebody's record, they would not be eligible for clean slate. And please let me know if I'm not being clear on that.
I guess to, kick up the conversation a little bit more in depth, in predecessors to this council and other groups that have sat around in this building talking about these issues. I know, and I don't know exactly who to direct my question to, but I know that in other states, the construction of their statutes are different in that they have a specific family violence or domestic violence crimes. And we don't have that here in Connecticut. And I know that's something that from time to time it's come up that maybe if we made that very broad update to our statutes, these kinds of issues wouldn't come up in this way. And that might also give us better data, frankly, on how many incidents of domestic violence we're looking at in our state. And so I just wonder if any members of the council have thoughts about that.
I'm not mistaken, the kidnapping first with a firearm, second, and second with a firearm, those wouldn't qualify for a clean slate anyway because of their classification. Is that correct for an A or B felony?
So, oh,
Those
I don't think we I see what you're saying. I don't think we distinguish between the two.
Yeah, I don't think C, B, and A felonies are included in clean slate, right? It's just misdemeanors, D felonies, E felonies. Right?
Yes, technically, I guess, but I think what has come up is with this list, should some of these, if there's a family, let's say it's a family violence and assault third degree, right?
Well, assault third, yeah, but I'm just talking about the kidnappings. Those are disqualifiers anyway, correct?
Yeah, my understanding is those would be A felonies. I think they put that on there, Mayor, just because there sometimes is involved, obviously, family violence within those charges. So, but yeah, I think that would be a bigger issue, as you correctly note, because it wouldn't qualify under 54-142A as it presently stands.
Senator Fletcher, I don't know if I'm going to answer your question correctly, but so bear with me. But I think that a lot of the DV charges are also things that non-DV cases could also have, right? So you can have an assault third, it's a bar fight between two people, but it also could be domestic. And I think for many years, I used to get a list of all the charges that were associated with a family violence case. And the charges are things I didn't even know what it was, but they're things like, even like larcenies and other things like that. You could have a larceny within a domestic violence situation or family violence situation. So I'm wondering how other states are able to do that in a way where is it just another flag? So it's assault third domestic violence versus what we do in Connecticut, which is, and I think the overarching thing is that whenever a defendant comes to the court, there's so many different ways and safety nets so that that case is handled as a domestic violence. The law enforcement, they do their paperwork and, they're strong with the LAP and all those other things that they do. The state's attorneys and the prosecutors, they certainly, when they read the police report, it becomes very clear. Our family violence victim advocates will flag cases that aren't really domestic at the time. And of course, our family services staff do as well. So I think that I think there's enough safety nets, but to answer your question, I think that the issue would be just how it is charged. So it'd be assault third family violence. The challenge for us, I think, as we sat around the table and thinking about this is, was there at the time the clean slate was thought about and the legislation was put in place, was there some ideas that some charges, regardless of family violence or not, were they not going to be included or included? Because I know that for years, I mean, this was like a long-term, a lot of meetings, a lot of discussions, what's in, what's out. I'm wondering if that was the intent or whether these are the unintended consequences of just that massive legislation going through. I think there's room certainly for us to close some gaps for sure. And I think that's really what Megan was talking about when we have cases in court and it's like, oh, something got clean slated. We have those discussions because it was somewhat alarming, to be honest. So I think there's room for some discussion amongst this council about how we would make some recommendations to yourself and other legislators. I think that's where it needs to be. Just initially to find out, honestly, what was their intent and is this what they intended or something else? And I'm not sure who would make those inquiries, but that might be a great place to start.
Thanks, Joe. And I think just to add to that, I think Merritt, just to kind of get back to what you were saying, Merritt, I think the question is, should they be added? Should these be added, when I say these on the last slide, regardless of other exclusions under clean slate? And I think that's maybe the bigger question for the group. Sorry.
I think it might, may I speak or?
Yes.
May I speak?
Yes.
Okay, thank you. It's Sarah Steer. A couple things. One, going back to what other states do, I know of some states out west that actually have specific statutes for assault, domestic, assault, non-domestic. And one of the reasons they do this is that if you get convicted of assault domestic, you can't have a weapon. But if you can get convicted of assault non-domestic, then you can have a weapon. So that's actually there to help plea bargain out, apparently, cases out where people want to keep their guns. So just throwing that out there that some states do that, maybe not for that purpose in other states, but I do know way out west that that is one of the reasons why they have that. As far as for having a list with specific enumerated statutes, you do miss some. You miss criminal mischief. People come in and destroy things. I'm also looking at the list now. I don't see risk of injury. And correct, larceny can certainly be part of these. Even a robbery could be part of these. I mean, there's all kinds of things. So I think it's always good to have flexibility in the law. So maybe making a finding on the record that a crime is committed during an act of domestic violence, or that is the act of domestic violence, that that finding could be made versus having specific statutes enumerated and then you miss some. Just a thought.
The one, I guess, Megan, is there, if I just respond to that?
Sure. Yes, Judge Doyle.
Thank you. That is clearly definitely one possibility, but then again, that also creates a certain level of, could it get missed in a busy docket? Could it get missed with inexperienced people? The thing I like about the judicial system now, especially in light of the 23 Amendment, is it is a kind of a computer program that has certain things it can look for and be efficient. And I think we have to keep that in mind too. I'm open to whatever the council thinks, and whatever I can do to find out information, I'll do. I want to make sure we think this through and we're careful with everything.
Absolutely. Thank you, Judge Doyle. I think Mark had his hand up.
Thank you. Thank you for the discussion. And I saw like two potential pathways in our discussion. The first is around which offenses are eligible for or not for clean slate. And the second is how we construct in Connecticut our statutes regarding domestic violence. On the clean slate side, I guess I would offer that certainly it's there are different ways of looking at intent, floor debate and other matters. I was thinking that a potential area of fit that could certainly be expanded or contracted based on the council's, thought is that this advisory council consists of people who are implementing statutes that have been enacted recently or long before, and the members of this council see the implementation of statutes in action every day, and therefore generate input that may be deemed valuable by policymakers regarding how implementation is proceeding, again, on a new policy or one that's been in place for a while. So perhaps if there are cases coming forward where they're family violence and they are eligible for clean slate and being erased accordingly, maybe we could track those in the appropriate way. If there are cases already that have come to the attention of members, and we could try to determine what led to these being erased. It was great that DESPP provided, their rubric for implementing this. Maybe there's more details we have on the case, and that we could bring to the appropriate stakeholder group forward to identify these cases as receiving erasure and discussing if that was, the original intent, or this is something that has come up during implementation. I think it's valuable to have people around the table who are working in a variety of venues every day, seeing how policies are being implemented. And to the extent we have some information already, I think it sounds like Madam Chair is off to a terrific start in engaging the implementing agencies. On the other more general matter of the organizing the statutes, it's great that we're discussing this. I know there's a proposed bill this session on organizing the hate crime statutes. Clearly, there is ongoing deep work needed to look at how our statutes are structured, and are they providing from sort of the writing on the page to the actual implementation of them. And there are already considerations that have been brought forward about what are the pros and cons of approaches that we have currently in Connecticut versus other states. So to the extent that's ongoing work we can do, that'd be helpful. And we have a case study, perhaps, if the clean slate legislation was constructed referring to this particular statute, that is giving us an ability to examine that statute. When was it last updated? Is it expansive enough or too narrow or appropriately sized to cover the charges that are needed? And again, we have now live examples of how it's being implemented. So I wanted just to try to share my thoughts about, where we are, and I hope that's helpful.
That was great. Thank you. Any other? Chief Fox?
So there's a number of ideas that have been advanced, and perhaps one additional one that I would put out in big picture for discussion. I certainly like the idea at the outset of approaching this through taking a look at what clean slate says is in and what clean slate says is out. A second thought for some of the offenses, because I will acknowledge when we talk about crimes like criminal mischief or even a crime like robbery, my brain goes back to the definition of family violence that I've had in my head for 20 or 25 or 30 years now. Criminal mischief, at least unless you start taking me down a road with very unique facts, doesn't seem to meet that definition. So I think another way, if we want to make sure that we're grabbing all of the offenses that are family violence as family violence, is to go back and look at that originating 38A, 38B, around there type statute. The third option, if you were looking for a statutory fix, and I'm just going to throw it out there, I haven't even thought this through, it just popped into my head. You could create some kind of a standalone, almost like family violence enhancement statute. And I'm not even sure what that looks like, but it would be an additional charge that law enforcement would apply. And I don't even know what the penalty would be, but it would be like, I'm listing off the assault third charge, I'm listing off a strangulation charge, I'm listing off a disorderly charge. And I'm going to know as another tool to cue people in that I'm going to lodge this addition. I don't want to make it sound like it's just an add-on charge to be mean, but some sort of an enhancement charge to make clear that we think it's in the DV world. I will tell you the one idea, and I mean this with the utmost respect, that I would be concerned about would be creating some sort of almost mirror set of state statutes where we were taking all of the crimes that we're concerned about and creating a subsection, sexual assault second, family violence. You'd be doubling the length of the penal code, and it would become a little bit overwhelming to work with from the police point of view.
Thank you. That was really helpful. Any other comments or questions? I'm not seeing any on Zoom at the moment.
If I could.
Oh, yeah, absolutely.
Hi, just this is there are a lot of good ideas out here and a lot to think about. So I think this is something that maybe we can take out. I don't know if we want to do a working group for this or if we want to talk about it, in subcommittee. It's a lot of good information, but it's a lot that we're gonna have to break down and take a look at. And I know for one, I need to do some deep thinking on this. So I just sort of wanted to put that out there.
Yeah, I don't disagree with you. I think we wanted to introduce the idea to the full council today and then talk, have a discussion, which I appreciate everybody contributing to. And then, yes, I do think we'd be looking to perhaps in the court-based issues subcommittee do a little bit more work around this.
I'm just wondering if the idea is that all DV cases were not supposed to be clean slated, and now that isn't the case, is we need that answer, I guess, right?
Yeah.
I mean, there had to be some thought process around that at some level, and without that answer, I'd hate to do all that work for someone other. We bring this to whoever, and that person or body or says that was our intent. We didn't want all these misdemeanors to be clean slated. So then I just want to make sure that the work is great. I think there could be some great solutions. It's just a question of how did that happen, and
process
is the idea that all domestic violence convictions should not be clean slated. If that's the thought, then I think there's an answer. There's your solution right there. But until we get that answer from the individuals who crafted that and put forth that clean slate, it's going to be hard. And I'm just kind of piggybacking off. I think that's really what Mark was saying is, is it an unintended consequence, or or maybe we just bring to that body, there is an unintended consequence, and can we fix it, and should we fix it? So that's all. And it should be perfect for court-based for sure.
If I may I put in a couple things. One, the statutes that are not included that you showed us, the unlawful restraints in particular, are oftentimes very common. If we can't prove a strangulation, that's the catch-all in those. And that, I think if we ran some stats and got how many DV cases we have are unlawful restraints, also assault third, that's probably one of the more higher numbers that we have. Also, I don't see risk of injury on there. So I think we really need to get the numbers, and then we can perhaps make our case better in terms of, hey, these statutes are falling through the cracks, and people need to keep these on their records. And maybe that's the best way to do it. I don't know. Just a thought.
And Sarah, going off of that, my attention was caught to violations of conditions of release. That's usually used instead of violation of a protective order all the time, so that defendants don't get a felony, they get a misdemeanor. So that's a really catch-all plea as well that defendants are getting. So that one is a high concern charge for me.
Yeah.
So, okay, I'm going to try to summarize what I'm hearing. So I think there's two possible next steps, maybe three. One is Senator Flexer. It might behoove you to meet with your colleagues that drafted the legislation and kind of get some answers as to the intent. At the same time, perhaps we can gather the data and at least have that data as that Sarah referenced to potentially be able to show the individuals that helped to craft the legislation. And then based on that, Johanna, to your point, it might make sense to then do a little bit deeper work if necessary, and if needed through the court-based issues subcommittee. Does that sound like a good summary of what I heard? Okay. All right. Any other discussion or comments that people wanted to just point out, even if it's just about the information on the slides or?
Can I just get clarification on the stats that Sarah's talking about? Because I'm going to probably be the person who's going to shepherd that on, and I just want to make sure I don't mess it up.
Yes, Sarah, there's a question for you to clarify the stats that you were referencing.
So I would say, Joe, and thank you for stepping up to do that, because I know it's probably a ton of work, is to get the stats for the statutes that are not included in 46B-38H that were on the slide that was shown by Megan. Also, I don't know if risk of injury was on there, but that's an important one too, because when we use that a lot down here when kids are exposed to DV and they're watching someone being assaulted or strangled or what have you. And so that really ought to be on there too. Nobody should be getting their record erased when they're committing a domestic violence act in front of a child. And so I think if we can go through that list, and I don't recall whether risk of injury was on there, add that too, and then see what kind of numbers you have and say, hey, these are a lot of cases that we have that people are going to get erased. In fact, you might want to compare that with the numbers of the statute in 46B-38H. So you might just get a rundown of, hey, breach of pieces are probably the biggest single one that you have in there, or and then assault there's probably pretty high up there as well. So you can show, I don't know, breach of peace I think is listed in this. I'm looking at it, but in terms of the unlawful restraint,
breach of peace is in 46. Sorry, breach of peace is in 46B-38H. So is harassment.
I mean, you've got disorderly conduct in there. You don't have assault third. That doesn't make any sense. So I think it was either an oversight or something that can easily be corrected, because if you have disorderly conduct and not assault third, why? So, so I think. Go ahead.
I'm going to request the data for 2025, the number of domestic violence convictions on the both lists.
Right.
Okay. Both lists. And then if there's any, and CCDV can work with you and make sure that the list is comprehensive. I mean, we put up the list that we thought today, and I obviously hear that some folks are saying that there's things that aren't on there that should be. So Joe, we can work with you
Yeah, no,
on that.
I'm gonna probably just ask for all of the charges.
Okay.
And then that way, then we can parse out what it'll be. Yeah, yeah, I got it.
You got it? All right. We'll help support you in that too. And then, yeah, in the meantime, Senator Flexer, if you can gain some clarity, that would be helpful. And then we can look at the data and then potentially be able to present that to those individuals would be awesome. Anything else? Okay, this was really great. Really good discussion. Thank you very much, everybody that participated. Thanks for rolling with me as I'm not part of DESP, but I did my best. So, and so we'll move on to the next agenda item under other business, just regarding the meeting schedule for the rest of the year. We're in session, so we anticipate that the next meeting would be in April. Senator Flexer, I think, has some suggested dates that you want to run through.
I think we were looking at and keeping mostly at a similar schedule until the end of the year, April 22nd, July 22nd, October 21st, 14th, October 14th. Okay, hold on. October 14th. And December is where I would like to suggest that we meet a little earlier, like December 2nd or 9th. That's my suggestion. And I'm open to opinions from the rest of the members of the council on December 2nd or 9th. Just to repeat again, April 22nd, and we'll make sure this gets sent out to everybody. April 22nd, 12:30, July 22nd, 12:30, October 14th, 12:30, and then the debate is on the 2nd or the 9th.
I guess I will just add to that for folks that want to add feedback to December. That is typically the meeting where the entire report is due. So as you're thinking about the date, just think about timing of being able to have that entire report due at that meeting. I would opt for the 9th if I were you, but it's up to you.
One question, Megan, is it, I don't want to throw this off, it's not a big deal, but would 1 o'clock be a big problem, or is 12:30 the best time for everybody?
I think 1 o'clock is fine. You're talking about for all the dates?
Or yeah, just in terms of, I'm being selfish, so I'll admit that up front. I have a feeling I'm going to be in trial in the April date. So 1 o'clock gives me more flexibility than 12:30.
Yeah, that is
But if
fine.
it's a problem for other people, please, I probably will be late.
Yeah, I'm looking around. I'm not seeing it being an issue for the folks in person, and I'm not seeing anything on Zoom. So 1 o'clock, we can do 1 o'clock.
Thank you very much. I really appreciate it.
So
Awesome.
just for clarity, we're going to have all the meetings at 1 o'clock.
Yeah.
Okay. And on December 9th.
Unless somebody else is really eager to meet on December 2nd, I think December 9th.
So one more time, April 22nd at 1 p.m., July 22nd at 1 p.m., October 14th at 1 p.m., and December 9th at 1 p.m.
Yes. Okay. All right. Great. Okay, so then the next item is just adjournment of the meeting.
So moved.
There's
Second.
Great. All in favor?
Aye.
Great. Thank you guys. Have a great rest of your week. Stay
Thank you
warm.
very much.
Thank you. Thank you.